Legislative powers. The powers of Congress under the United States Constitution. The Constitution separates powers into three branches of government. Congress makes laws, the judiciary settles cases and controversies, and the President implements the government's decisions via the executive branch. Congress cannot interfere with the President and impede him in carrying out his constitutional duties. So although the Senate must be consulted by the President, Congress cannot appoint or remove staff to work under the President in the executive branch. The 10th Amendment provides that the federal government only has powers specifically assigned by the Constitution and its amendments. All other powers are reserved by the states. Police powers are not enumerated, so are retained by the states. Congress does not have police power, so it cannot regulate in order to promote public health, safety, morality, welfare, or conduct of its citizens in the interests of the common good. Article 1, Section 8 enumerates the powers provided to Congress. These powers include matters such as the collection of taxes, regulation of interstate commerce, coining of money, patents, bankruptcies, armies, and the Admiralty. Congress is able to do anything that is necessary and proper to carry out a power. The bar is set relatively low, and necessary and proper is interpreted as anything convenient and useful in carrying out the power. This can extend the scope of congressional powers considerably. For example, Congress has no enumerated power to form a national bank. However, the bank was considered necessary and proper in order for Congress to exercise its taxing, spending, and other powers. The necessary and power clause is not an independent power, but a supplement to amplify the other enumerated powers. Of course, the federal commerce power is used to regulate the movement of goods across state lines. But it's also available to regulate the instrumentalities of commerce, such as transportation, telephone, and other forms of interstate communication. The commerce power has very broad reach, and this is the chief way in which Congress regulates. Almost every regulatory power passed in the United States is passed pursuant to this commerce clause. Even intrastate matters within a single state can become regulated by this power when they're deemed in aggregate to affect interstate commerce in some way. The Commerce Clause has been pushed to the extreme, but has reached some limits in the extent of its powers. Cases have shown that Congress cannot use the Commerce Clause to force the states to enact their own legislation. It's not a license for the federal government to commandeer the state legislature. Congress can pass a law regulating farmers that affects farmers within all states, but Congress cannot pass a law forcing the states to regulate their own farmers. Congress has the power to tax and spend for general welfare. General welfare is interpreted very broadly to cover anything Congress wishes it to cover, so the constitutional limits on the power of Congress to tax and spend is virtually unrestrained. Congress is restricted from commandeering state legislatures and forcing them to enact certain laws. However, in addition to exercising its own enumerated powers, including the expansive reach of the Interstate Commerce Clause, Congress uses other techniques to force the states to do their bidding. When Congress has powers to regulate, but wishes the regulation to be undertaken by the states, Congress can threaten the states that if the states do not regulate in the precise manner requested, Congress will exercise its own powers, step in and regulate themselves. Facing loss of control and the threat of federal regulation, the states have little choice but to enact the laws required by Congress. Money talks, and Congress has found over the years that spending can be a huge source of influence over the states. So when the federal government wanted to raise the drinking age in the states, it threatened to withhold federal funding for roads and transportation unless the age was raised from 18 to 21. As drink driving was argued to be an issue of the young and a hazard of transportation, federal transportation funds were deemed reasonably related to the law requiring the raising of the drinking age in the states, and the conditioning of these federal funds was held to be constitutional. The Civil War was fought between various U.S. states over issues of slavery, equal protection, and equal rights to citizens black and white. Following the war, Congress was provided with new powers to enforce the new constitutional amendments against the states. Congress has powers to enforce the 13th Amendment prohibition against slavery on individual citizens as well as the states. Anyone involved in slavery is answerable to the federal government. The 14th Amendment was aimed at the states, to force the states to provide equal protection to all citizens. So the powers of Congress here are focused on and restricted to enforcement against the states. The 15th Amendment protects the right to vote for former slaves and non-whites. The powers of Congress have been held to be extensive in forcing the states to allow individuals the right to vote in a wide range of settings. Congress is able to delegate its powers to specialist agencies, and this it does extensively. Regulation of the securities markets is delegated to the SEC. Regulation of drugs and food is delegated to the FDA. These agencies are not managed by Congress, but fall under the management of the executive branch. The only constraint on this power is that Congress has to provide the agency with some intelligible principles, so the agency can be guided by some standard. Once Congress has delegated power to an agency, however, Congress cannot veto laws and decisions made by the agency without going through the full legislative process involving both houses and the approval of the President. It was found unconstitutional for Congress to delegate power to an agency, but retain the right to veto, as this would short-circuit the legislative process laid out in the Constitution. We want Congress, the President, and judges to be free to make decisions and act in the best interests of society without worrying about lawsuits resulting from their decisions and actions. So Congress, the President, and judiciary have certain immunities against suit and prosecution. Congressional immunities derive from the Speech and Debate Clause. Congress can't be prosecuted or sued for official legislative acts. Official legislative acts include voting, committee reports, but the scope of immunity is narrowly tailored to aspects of the legislative process. Legislators are not immunized from their conduct outside the legislative process. If Congress passes a law that violates a prior international treaty, then the law controls. The determinative factor is which is later in time, the treaty or the law. In this way, legislators have the power to override commitments made by the U.S. to other nations.